Good afternoon. I am coming to you today to discuss a recent case that was decided by the Illinois Appellate Court on September 16, 2024. The case has a lesson for everyone that anyone should consider. The case is Kenneth S. Brody versus Stephen L. Hoch, H-O-C-H, and Karen L. Mansfield. 2024 Ill App 1st, 231524. Essentially, the plaintiff is a resident of Tennessee. The defendants are both residents of California. Plaintiff was involved in a spousal support dispute with his ex-wife, Susan Hoch. And what happened is some anonymous letters were sent to his employer accusing him of wrongdoing. So let's go through the facts a little bit. Paragraph 3. Briefly stated, Stephen Hoch was involved in spousal support proceedings in California with his ex-wife, Susan Hoch. During those proceedings, Stephen discovered that plaintiff transferred over $5,000 to Susan in June 2019. According to plaintiff, he loaned Susan the money to cover a debt owed to her by a friend. Plaintiff, however, had never met either Susan or the friend. Instead, a mutual acquaintance of plaintiff had arranged the loan. Now we go back to the spousal support litigation. They don't say where it's pending, but during the spousal support proceedings, Karen Mansfield, that's the defendant, who was in a romantic relationship with Stephen, mailed a signed settlement offer to Susan concerning Stephen's spousal support obligations that contained, among other things, statements indicating that Mansfield had personal knowledge of Susan's finances. Mansfield gave Susan until the end of February 2022 to accept her settlement offer. Less than 2 weeks after the offer expired, 5 identical anonymous letters were sent to DRW's head office, that's plaintiff's employer, which is located at 540 West Madison Street in Chicago, Illinois. The letters were addressed to the CEO and founder of DRW, as well as current and former DRW partners. The letter claimed that plaintiff, DRW senior executive, was engaged in, and I'm not going to repeat, basically engaged in some wrongful financial conduct. So, the plaintiff in this case, and this is very clever what he did. He undoubtedly suspected that the person who wrote the anonymous letter was the same person who had written the settlement offer. So, paragraph 6. Plaintiff thereafter had 2 of the 5 anonymous letters DNA tested and examined by a document examiner. The DNA matched the DNA found on Mansfield's signed settlement offer to Susan. Specifically, Beth Crispin, a certified question document examiner, inspected the letters sent to DRW partners Glenn Schwartz and Fred Schuster, as well as Mansfield's settlement letter to Susan. Crispin concluded that it was, quote, probable that the author of the letters was the same person who authored the settlement letter, namely Mansfield. Moreover, the DNA testing conducted by Technical Associates, Inc., examined the letters sent to DRW partners Jeffrey Leavoff and Glenn Schwartz, along with Mansfield's settlement letter. The test revealed that it was extremely likely that the DNA found in the 3 letters belonged to the same individual who authored the settlement letter, and that the odds of another person having the same DNA profile were 1 in 16.9 septillion. So the trial court, we have a plaintiff who is from Tennessee, the defendants are from California, so they moved to dismiss the case on the ground that there was no jurisdiction over them in Illinois. The trial court accepted that reasoning and rationale, but the appellate court, the Illinois Appellate Court, reversed. And then we can listen. There's another quote from paragraph 24. In this case, plaintiff's complaint alleged that defendants purposely directed their activities toward Illinois when they intentionally sent 5 defamatory letters about plaintiff to DRW partners located in that state. By sending the 5 letters, defendants established minimum contacts with Illinois, thereby satisfying the first due process requirement. Further, plaintiff's alleged injuries arose out of and were directly related to the defamatory letters which were published in Illinois. Accordingly, defendants' contacts with Illinois gave rise to plaintiff's suit, satisfying the second requirement. And the court ultimately finds, quote, based on the foregoing, we conclude that exercising jurisdiction over defendants in Illinois is reasonable, even though they are not residents of the state, since the remaining factors outweigh any burden defendants may face in having to defend themselves in an Illinois court. So, essentially, this is a important case because for 2 reasons. First of all, none of these people are from Illinois except for the employer, the target of the letters. And it's worth reflecting that the letters implied that the defendant, the plaintiff, that the plaintiff was engaged in essentially financial dishonesty, and this is what we know, what lawyers describe as defamation per se. Quote, words that impute a person, 1, has committed a crime, 2, is infected with a loathsome communicable disease, 3, is unable to perform or lacks integrity in performing his employment duties, 4, lacks ability or otherwise prejudices that person in his profession, and or 5, has engaged in adultery or fornication. So they attacked the plaintiff by trying to tell his employer that he was they alleged that he was a bad person, dishonest. These are serious allegations. Most defamation cases you read do not have this quality of preparation and the quality of the proof. They have already, with the DNA evidence, they've already gotten themselves a long way past the problem you would have in a normal anonymous letter case, that there would be no way to prove who sent the letter. Well, here there is. They matched the DNA matches up with one of the defendants. So this is a case that, and the trial court dismissed it, but they said, no, you did enough here. You wrote to an Illinois employer. Even though Mr. Brody lives in Tennessee, he works for an Illinois company. You tried to hurt his relationship with his employer. That's what they're saying. So the case states a claim. The case will be returned to the trial court for trial. Just a disclaimer that I'm merely offering my opinion of the case as a legal case. I make no opinion about the truthfulness of the allegations in the complaint. I'm simply offering a legal opinion about the plaintiff's case. I will say that the legal work done by plaintiffs was outstanding in this case, and they were willing to follow through even after they got a tough decision in the trial court. So I give them credit for their excellent work on this. Again, this is my opinion. I make no claim that I know what happened here, because I didn't, but I have to credit plaintiff and his counsel for being smart enough to do DNA testing of the anonymous letter and then to compare it to the settlement offer that he previously received in the spousal support litigation. This is thoughtful, intelligent preparation of a plaintiff's case, and that is really what makes it worthy of your attention. Thank you.